it's what I call those had to be there moments. I've appeared as appellate counsel in post-trial motions, like on a motion for new trial, say, and at the hearing, I'll be there along with the judge who had presided over the trial and with opposing counsel who had been trial counsel. And they'll both say, well, Mr. Kowal was not here. If only he had heard the witnesses, if they had heard the arguments that had been made the whole time, the tenor, everyone understood this is what the case was really about. And I think, have you ever told one of those jokes that kind of fell flat, and then to kind of regain your composure, you say, well, you had to be there. If you had to be there, it's not much of a joke, right? It's an inside joke, and it doesn't work. Inside jokes don't work in the law. All you have is the record, because you know who else wasn't there at the trial? The Court of Appeal. The Court of Appeal is going to be more like me, and they're more likely to have my impression after looking at the record than they're likely to have your impression from having that front row seat at trial. So I find I find it somewhat frustrating sometimes that judges sometimes don't realize that the only thing that exists is what's in the record, and just saying, well, you had to be there, is not going to cut it at trial, and it oughtn't cut it in post-trial motions. And so that's something I try to impress upon judges in post-trial motions, but with only limited success.